Good afternoon, evening, morning, whatever. Not legal advice. Please like, subscribe, share, comment, show to your pets. Tonight, I'm going to talk about a little bit about the schedule. I received an order that was agreed upon by the plaintiff and Elon Musk and counsel in the pay package dispute in Delaware. This involves the attorney's fee motion and how it's going to go from this point in terms of the appeal. So I wanted to bring everybody up to speed as to how it will go so they can have at least some rough idea of when these issues will be decided. Of course, before they go, as is my custom, um, lawyers will wish you a happy holiday, but never guarantee it, and name their daughters Sue. And when a chicken graduates from law school, they officially become a chicken tender. Anyway, so the order was entered on or about March 18th. This is in the Tornetta versus Musk matter. There was a stipulation entered between the parties. So the parties agreed upon a briefing schedule for the attorney's fee, the motion. The attorney's fee motion was filed by the plaintiff's counsel, in which they are seeking the equivalent at the time of $6 billion in stock for their work based upon some calculation of cost benefit to the company, which you can argue about. So there was an agreement. And now that I have this, I can kind of figure out at least some idea of when the appeal will be heard and when we should expect a final decision. So it says that on or about May 1st, Tesla will file its basically its opposition brief to the motion for attorney's fees. The end of May, Tornetta's counsel will file a reply. The parties are supposed to get together on or before June 5th and either agree to a judgment or not. They're not going to agree because they're not going to agree as the attorney's fee award, or I'd be surprised. So there'll probably be two proposed judgments, two proposed orders. The court will then have that. The court then set a hearing on July 8th and they'll review the paperwork. So and there'll be an oral hearing. Now, before the oral hearing, depending on how the judge handles it, either that judge will prepare a tentative ruling, basically a preliminary ruling before the oral argument that will be difficult to overturn, or she, in this case, will not have a tentative ruling established. We'll just let the parties argue about the case, and then we'll make a ruling. So that's July 8th, 2024, where the actual hearing before Judge McCormick is heard, and that's on the motion for attorney's fees. The judge will probably rule if the judge considers the matter, rules most likely within 30 days. That brings us to, I think, for my purposes, I think August 9th was the date. The notice of, I'm going to presume that things happen rapid fire. So this might be slightly expedited, but it'll be plus or minus in the end, just to give you an idea. So let's say August 9th, final decision, judgment. The notice of appeal, which will be filed, has to be filed within 30 days. So that brings us to September 9th. A record has to be prepared on appeal. In other words, all the pleadings, everything that was filed in the case will be part of the appeal because the underlying decision, in essence, will be in consideration along with the attorney's fee award. The underlying decision will be there because the attorney's fee award is based in part upon the cost savings and a benefit, quote unquote, to Tesla. So the entire record will be before the court. So literally, that has to be prepared by the clerk. Then it's distributed to both sides. Then they prepare briefs. So I'm giving 90 days for preparation of the record. Might take longer, might take a shorter time, but that would bring us to December 9th, 2024. The opening brief technically would be due in 30 days after that, but realistically, there'll probably be an extension that's sought. So I'm going to figure 60 days for the opening brief. That will get us to February 9th. The opposing brief, I'm figuring again another 60 days. Could be longer, could be shorter, but it's a fair estimate. April 9th. A reply brief, 30 days for this, another fair estimate. That brings us to May 9th, 2025. The court then has to review all the filings. The clerks have to review everything. Doesn't necessarily have to have an oral argument. So if there's no oral argument, and I think in this case there will be an oral argument, but if there is no oral argument, the court can rule within 30 days of the last brief being submitted. In this case, so that if the last brief was submitted May 9th, 2025, the court could rule, and this is the Supreme Court of Delaware, by the way, the court could rule by June 9th. However, I would anticipate that the court will have a hearing for due process reasons and because this might be the largest case that the Delaware Supreme Court has ever heard. I think it would be improper if they didn't permit a hearing. So if the last brief is submitted May 9th, then a hearing, I think, would likely occur on or about July 9th, 2025. A decision has to be rendered within 90 days of that date. That would bring us to October 9th, 2025. So, subject to a lot of fudging, my estimate of the timing of this appeal and when it will be finally decided is sometime the latter part of 2025. Now, what will happen in the meantime when there is a final judgment, and I think I threw out a date of August 9th, I think, as a date, a prospective date, as a final judgment. Once there's a final judgment, then I would expect Elon's team, if there is a judgment for an award of any amount of attorney's fees, which I would expect, that Elon's legal team will then seek a stay so that the plaintiff will not be able to take any action to enforce the judgment, collect those shares, or whatever other action they would do. So they can file a motion to request the stay. There's a formula that exists, and it might be relevant for everybody. The formula in deciding whether a stay should be issued in Delaware is you have to look at the likelihood of success on appeal, whether if there's not a stay, that the person who's seeking a stay will suffer irreparable harm, whether any other interested party will suffer substantial harm, and whether the public interest will be harmed if the stay is granted. And I think if you look at those factors, although I'm not arguing them, but if you look at those factors, a lot of them will fall on the side of either shareholders as interested parties or in the public interest, and also might relate to suffering irreparable harm because if in effect the shares are issued to the attorneys and they sell those shares are gone. There's no way of undoing that anymore. So I think there's a decent chance that if Elon's attorneys seek a stay, that they will prevail. If they prevail, they still have to post some kind of a bond to cover the potential judgment amount. They have to pay for the bond. They have to collateralize the bond. But if they do that, then they would not be subject to having the judgment enforced. So I would expect that. So that's kind of the summary. So I'm expecting late 2025, the end of this. I expect a motion for stay sometime middle of this year. I think there's a good chance that the stay motion will be granted, and then a bond will be obtained, and then this will be litigated. And I expect it to be litigated fiercely, and I will keep you apprised. Everybody out there, be well, take care, have a great day, and be well.